This is Bloomberg Law with June Grasso from Bloomberg Radio.
In the biggest tech antitrust case in 3 decades, Google avoided a breakup after a D.C. federal judge ruled against the government's most severe proposals for remedies, including a forced sale of its Chrome browser. Judge Amit Mehta had already found in August of 2024 that Google illegally dominated the search market by paying more than $26 billion to Apple and other companies to make its search engine the default option on smartphones and web browsers. Tuesday's ruling was all about the fix, and Google will have to make some concessions, including sharing online search data with rivals and ending exclusive contracts for distribution. My guest is antitrust law expert Harry First, a professor at NYU Law School. So on its website, the Department of Justice says Department of Justice wins significant remedies against Google. But this falls far short of the severe remedies that the government wanted. How much of a setback is it for the government in its attempt to curb the power of the biggest tech companies?
Well, people often talk about things as being a win-win, and that's a good thing. So I think that the judge's decision is a win-win, but not a good thing. So why is it a win-win? Because the Justice Department and the states get something, and Google gets more by there not being more. So I view it as win in sort of 8-point type on the government side and win in sort of 16-point type on Google's side. So here's what I mean. It's not a significant victory for the Justice Department. They did win some things, and, maybe that will help bring some competition into search. But I think Google won a lot by not losing very much. They get to keep Chrome. A lot of the remedies that the department asked for and got even were cut down, circumscribed, diminished. And, whether what the judge did will end up changing the search business, I doubt, but who knows? But we've now passed the point where the question will be, will we get competition? And the question will just be, is Google complying with the decree? Of course, all of that comes after a round of appeals. So there's much more to this, but in terms of, the overall feeling about what we've done, I think it's, from a public point of view, a disappointment.
So the big headline was always, will Google be forced to sell Chrome? Will it have to divest? So Google doesn't have to do that. Why did Judge Mehta decide not to make Google divest Chrome?
So this is the second point that pervades Judge Mehta's decision, rightly in a legal sense, but I think not so correct from a policy point of view and really where the law ought to be. So this is in many ways a very conservative opinion. It's the judge expressing what judges often express, is that, they understand the limits of who they are, what the institution can do, and what they want to do on an ongoing basis. So they're conservative about this. And here the government's plaintiffs are asking them to do some pretty strong restructuring of one of the superstar firms in the United States. So you got to be a little modest. Now, the judge backs up his modesty with a lot of quotations from the Court of Appeals and recently from the Supreme Court in a different antitrust case, opinion written by Justice Gorsuch, which counsels, let's be careful a little bit. So the ask that Chrome be divested, structural relief is something that the D.C. Circuit itself, remember, Judge Mehta is a district court judge overseen by a court of appeals from the D.C. Circuit, District of Columbia Circuit. So he's required to follow the law from that circuit. The law from that circuit on remedies is actually pretty conservative and cautious. And that stems from actually the Microsoft case, which is much the template for the complaint that the government filed and for the government's theories. So, they said, well, when it comes to structural relief, restructuring, reorganizing a company, you really need some strong proof before you do that. You need to watch out. And so he took those admonitions to heart and just didn't find enough to overcome that sort of a presumption that, you don't do this unless you really have to do it for effective relief. And this then goes to the second part, that it maybe the government didn't make an effective enough case for divesting Chrome and maybe made it seem too easy. So, stuck with all of that, he backed away from it.
How much did AI play into his decision?
So, that's maybe the real lead, which we're now burying. I think his decision is all about AI, frankly. And I think that he's betting, and many in the industry, and if you listen to some of the news shows, are just simply betting that AI is going to replace search as we know it with something else that's not search as we know it, or maybe as you and I know it, but just simply getting information. And that Google search, that product, no matter what he does in this opinion, is going to be eclipsed by some AI product. And I think that permeates. I think that he views generative AI as coming to the rescue of competition.
Yeah, some say it's already eroding Google's dominance.
The data seem to show, he mentions this in his opinion, that searches on Safari have decreased. People seem to be going directly to, ChatGPT or Perplexity or some of these other AI assistant things and just getting information that way. And this is the destructive force of innovation, as the economist Joseph Schumpeter talked about many years ago. So maybe he's right, and, that may mean that sort of didn't matter what he did so long as AI lives. But of course, the worry is that we'll just replicate the current structure of the tech platform. Superstar firms will just control AI, and we won't have moved to new competition, but we'll have a different product.
He's ordering Google to share data with rivals to open up competition in online search. Google has to share some of the data with competitors, but not some of its most important data, would you say?
Well, here again, it's hard to say exactly what are important data. You could say all of the data are important, the more. But, this particularly involves the search index, which is something that Google has done really well. And the government, in some ways, didn't ask for as much as it could, which would have been a license to the index itself. What they wanted is some help with the data so competitors could build an index. And even with that, the judge cut down the kinds of data that will be required to be disclosed. And to me, even more importantly, the timing of the disclosure. So for some of these data, it's a one-time snapshot, which strikes me as, the judge calls it a kickstart for competition. Like a kick in the rear, I don't know. A one-time thing for some very important parts of some basic information to help them put together a better index of the web. There's an awful lot of information out there, and indexing it is critical for an effective search engine. And, when it comes to sort of this user-side data, the click and query, what we do when we get free search is create data that's worth a heck of a lot of money, for which we don't get paid, we being you and me and all the other users. But these data, here again, the judge cuts down the request, gives some amount of the request, and then sort of puts on some limits yet to be decided about how often this will be disclosed. More than once now. It's not just a snapshot, but the cap yet to be determined by this technical committee that the decree is going to set up. So I don't know. It's hard for me to say exactly, will this enable competitors really get an effective competing search engine, or will it not quite be enough? And in some ways, this goes to what I've always viewed as the underlying problem with these decrees is a judge trying to say what competitors need to succeed instead of a judge saying, don't ask me, just come back, Google, just come back and let me know whether there's competition or not. And if there isn't, we're going to have to do something more about it. Trying for judges or even the Justice Department, which apparently at least is still made up of some lawyers, trying to design these remedies is tough. And you can feel it with what the judge has written in this opinion. It's hard, and trying to figure out what the effect is going to be. I mean, he says at the beginning, I don't have a crystal ball. Other judges have used that worry as well when being asked to predict effects in future markets.
Coming up next on the Bloomberg Law Show, I'll continue this conversation with NYU law professor Harry First. Google has already said it's going to appeal. Will Judge Mehta's decision stand up? I'm June Grasso, and you're listening to Bloomberg. A federal judge ordered a shakeup of Google's search engine in an attempt to curb the power of an illegal monopoly, while rejecting the government's attempt to break up the company and impose other restraints. The 226-page decision made by D.C. federal judge Amit Mehta will likely ripple across the technological landscape at a time when the industry is being reshaped by artificial intelligence, as companies like ChatGPT and Perplexity try to upend Google's long-held position as the Internet's main gateway. Those innovations and competition reshaped the judge's approach to the remedies in the nearly 5-year-old antitrust case. Judge Mehta wrote, unlike the typical case where the court's job is to resolve a dispute based on historic facts, here the judge is asked to gaze into a crystal ball and look to the future, not exactly a judge's forte. I've been talking to antitrust law professor Harry First of NYU Law School. So, Harry, the judge is directing both sides to come back by September 10th with a new remedy proposal consistent with his ruling, or file a status report outlining any disagreements. Do you expect anything real from that?
I think what he's looking for is he's got to write this down. He's got to enter a decree that has definitions, that has specific language, that's understandable. I mean, the first challenge is figuring out sort of what to accept in the parties' proposals. But the second challenge is the drafting of that decree. I think that's what he's looking for next. Give me your actual proposed decrees. The parties have done that. They have proposed final judgments, but now they've got to take, here's what he's ordered, and I think he wants language now. He also hinted at some fallback potential remedies. One of the problems I think that he faced, and it surfaced in a question that he ended up posing on the record, which is pretty rare. Tell me why you asked for this particular thing, Google. Please explain it. And he had a final hearing, but as he sits down to start to write the opinion, he's thinking, I've got an interesting, different idea here that no one's proposed to me. Maybe you should think about it. So there's sort of some version of like conditionality, maybe on payments for, not allowing certain kinds of payments for, you said you can make any kinds of payments, but maybe there's a fallback position. Maybe they had a fallback position for Chrome that they might want to articulate now. Just they said, let's get rid of it, but maybe there's some fallback. So this may be an opportunity also for the parties to propose, in addition to clarifying language, some modifications for what he's imposed. So maybe that will also go on as well. So who said this, Yogi Berra? It's not over till it's over?
And it was Yogi Berra.
Right, well, allegedly. Apparently he never said anything that he's supposed to have said, which is another thing.
Yeah, we'll discuss that next time. Now, as far as pay to play, the judge said that this exclusive deal that Google had with Apple, where it pays it something like $20 billion a year to be the search default on iPhones, et cetera. So they can still do that, but it just can't be exclusive.
They can pay for default, but can't keep others from, putting another search bar or who knows what, but they can still pay for default, so they can pay anyone for having the default. Defaults were never exclusive. I mean, they were exclusive, so you can only out of the box if you were an original equipment manufacturer, handset manufacturer, and exclusive to put the Google search bar on if you wanted other programs, or, an exclusive if you have an exclusive, you get revenue shares, things like that. So maybe not that, but he basically said you can pay for defaults, which the testimony from the behavioral economist was that's the factual equivalent of a near exclusive, because people don't change from defaults very often. It's an old behavioral habit with which we're very familiar and with which Google's familiar. So the judge did suggest, he did this in a footnote.
You read the footnotes too, Harry. I'm impressed.
Hey, I'm a not quite reformed law professor, and we always know you put the good stuff in the footnotes. But anyway, at least that's our version. But there is a footnote, it's note 14, and he said he could revisit the idea of a ban on paying for default, but allowing to pay for distribution. So you could say, okay, if you distribute Google search, that's fine, we'll pay you. But we can't pay you to make it the default search engine. Now, he said, nobody sort of raised this. Hello? No one raised this, so I don't know the effect. Hello? So maybe we'll get something. You could wonder whether that makes any difference, frankly, because once you distribute it, given the strength of this default in most people's experience, it may not make a difference whether you label it a default or not. If you get, the Google widget, on your phone particularly, where it's very strong, because you want to use Google search, and whether it was a default or not, or whether it's a default in your Chrome browser, which it's going to be, you'll use it, and, the payment won't be for requiring it to be a default, say on the iPhone, but Apple may still make it a default unless they're offered a better alternative, which the testimony from Eddie Q, the Apple guy involved, was that he wouldn't buy Bing for any amount of money ever, apparently. So he needs something better, and is he going to take away Google search full from Apple users? I doubt it. So there might be some modifications, but at the moment, Google can still pay for default. And here again, this was the judge's concern for the impact, in being modest sort of, the impact on, you could say, the whole ecosystem of stopping those payments and, maybe wrecking Firefox, DuckDuckGo, even you seem to be concerned about wrecking Apple. I didn't know that Apple was in such bad shape, but there we are.
Well, the government said it's considering its next steps. I mean, I don't know what next steps it can take besides appeal, but Google has previously said it's going to appeal. So we assume it'll go to the Supreme Court, right? It could be years and years before this gets implemented. Yeah,
it might not go to the Supreme Court. The court doesn't have to take it. Who knows? The court didn't take Microsoft, for example. So yeah, maybe yes, maybe no, but the years is right. This will be a while yet, and we haven't seen, but could see political interference with this. We really don't know. So there's a lot between now and then, I guess. But the liability decision, which he made more than a year ago, I guess, is that the whole bundle is subject to appeal once a final judgment is entered, which he has not done yet. So once that's done, then the parties have, I think 60 days to file their notices of appeal, and then the process starts to play out in the Court of Appeals, unless they start some sort of settlement negotiations or something.
I mean, do you think that his opinion is conservative enough to survive the D.C. Court of Appeals?
So he did a lot to try to survive review by the Court of Appeals. I mean, he relied quite heavily on, key decisions, particularly the Microsoft Remedy decisions. And he also, by the way, bolstered one of the potential weaknesses in the liability decision while he was at it. So I think it's not perfectly bulletproof. The aspect of letting AI companies share in some of these data, if I were Google, I would be hitting on that, whether that was, not warranted, given, as he started out by saying, there was nothing at the trial about AI. And there are ways of casting what he did as maybe not within the bounds of what the goal was in the trial. So there's some potential issue there, and I think it is certainly possible. I assume Google will pursue that. So I think it's a pretty, it could be more conservative, I guess. He could have just given Google what Google wanted. But it's a carefully drawn opinion, and, time after time he sort of knocks the government plaintiffs back a bit by saying, you've overreached, you're asking for too much, we need to be modest, et cetera, et cetera.
Harry, the trial later this month to determine remedies in a different case brought by the Justice Department, where a judge found that Google holds illegal monopolies in online advertising technology. How does that threaten Google? Is it more of the same?
Well, it is a little different. There's a bit of remedy on advertising, but not very much because it's so much directed at effect on the search engine market. So directly, not so much. Indirectly, I think we have to see yet, because from the beginning, the Justice Department has asked for structural relief to break apart the way Google does advertising, to break it up, in fact, and have them divest certain parts of its advertising stack, as they call it. So this opinion is very skeptical about this structural relief. Said, if nothing else works, then that may be possible. But the ad tech case may be a case where, it's been directed at structural relief. So that may be okay. Another aspect is how much money Google has made from advertising. So it reinforces the notion that this has been a monopolized market. So, that may have some effect. It's important to note that case is in a different federal circuit. It's not in the D.C. circuit. And it may be that the Justice Department chose to file there for a number of reasons, but one of it may be that on remedy, wanting a structural remedy, the D.C. circuit is a bad place to bring a case like that, given Microsoft. So maybe they were trying to avoid that by being in a different circuit, in the Fourth Circuit. So we've yet to see. I think she's been holding up on this, pending Judge Mehta's opinion on remedy, but, they are fencing along on the remedies hearing in that case. So that should happen relatively soon.
Yes, I Googled it, and the trial is scheduled to begin on September 22nd. Thanks so much, Harry, as always. That's Professor Harry First of NYU Law School. Coming up next on the Bloomberg Law Show, more than 1,000 HHS employees are calling on RFK Jr. to step down. I'm June Grasso, and you're listening to Bloomberg. Today, more than 1,000 current and former employees across the Department of Health and Human Services signed a letter calling for Health Secretary Robert F. Kennedy Jr.'s resignation, accusing him of endangering the health of Americans. The new letter comes just 2 days after 9 former directors and acting directors of the Centers for Disease Control and Prevention wrote an op-ed also condemning Kennedy for endangering every American's health. Dr. Richard Besser was one of the signees.
We have grave concerns that the Secretary of Health is endangering the health of people across our nation by not letting the agency do its job, not following the science, and putting out guidance around COVID vaccine that is leading to confusion.
But it appears Kennedy is not listening. He wrote in a Wall Street Journal op-ed published today that his changes are restoring trust in the CDC that was lost during the COVID pandemic. That's something he said before.
I'm very confident in the political staff that we have down there now that they're going to be able to accomplish that and ensure the competent functionality of that agency.
My guest is Harry Nelson, a partner at Leech Tishman Nelson Hardiman. Harry, explain some of the concerns that healthcare professionals have about Kennedy.
Yeah, I think first and foremost, what they're sounding the alarm over is the politicization of public health itself. It just seems that, that we're kind of in a battle where science is losing ground over ideology in steering health policy. So, I think that op-ed was intended to be as public a form of rebuke for RFK and the way he's reshaping the CDC and public health policy as could be. It was the vaccines last week or two, but it's going to move on to, the conversation over environmental causes of autism and all the ways in which he has really become, very politicized and moving away from science and kind of driving our public health policy.
He's canceled medical research. How much and in what areas?
Well, the cuts on medical research have mostly come through National Institute of Health, NIH grants, over $1 billion in NIH grant cuts across different institutions. And, just a massive, reduction in kind of established leadership in positions that were previously not considered political, from the leadership of CDC itself, removing Susan Monarez after just a few weeks on the job, to completely clearing out the advisory committee on vaccines. And so he's just done a wholesale shift on public policy in ways that we'll be experiencing the ramifications of for years to come, if not decades.
What probably prompted this, the final straw, if you want to call it, is the attempt to fire Monarez. So she was just in there for a month. Didn't they know what she stood for? What happened?
I think essentially she was really just following sort of standard protocol at the CDC, and it was clear that there was tension escalating as there was a push from RFK and the people around him to narrow federal COVID vaccine recommendations, to get rid of the standing advisory committee, to start really changing the Vaccines for Children program. And essentially, it became clear that she was standing in the way of some of the very aggressive moves that RFK and his people wanted to make.
RFK promised he wouldn't take vaccines away from anyone. But tell us what happened with this guidance, the recent guidance, and what it means for people who not in those categories but want to get vaccines.
So the main thing was that, the FDA essentially slammed the brakes, you could say, on sort of broad access to COVID boosters. Vaccines will remain available and covered for 65 and over, and for younger people who have a specific risk factor, but in general are not going to be available for people under 65 without some specific risk factor. And of course, it's an issue of access. It now appears that there are a number of states in which it's going to be very difficult to get vaccines, and also the cost of vaccines, because the change in health policy is going to mean that insurance companies will not be doing any cost sharing on them, so vaccines will be much more expensive. It's clear that there's going to be a difficult time for people who are wanting to get vaccinated, and the real question that will come likely at the end of the next flu season that's not yet here is what the death rate, what the hospitalizations will be. I think a lot of people will be watching closely to see what the net impact of these changes is going to be.
So is that for the COVID vaccine? What about flu shots?
This was specifically a COVID policy, but it's clear that there are going to be significant limits on the flu vaccine as well. But this specific policy was update to eligibility for the various COVID-19, vaccines you'll remember as Pfizer, Moderna, and Novavax. It's certainly going to have a broader effect on access to other vaccines, just because so many pharmacies and insurance companies are taking their lead from COVID policy for purposes of broader, like influenza B and other flu-related shots.
Is there anything that can be done, or is it just a question of, Kennedy's there and that's it, unless he's fired for some reason?
Obviously, we're going to see lawsuits undoubtedly, and challenges to the firing of the CDC director, essentially, questioning whether there's a violation of separation of powers here and whether there's any kind of retaliatory aspect to this. There certainly is the possibility that states could start enacting their own coverage mandates. We already see California, New York, Massachusetts are kind of moving in that direction. Congress could step in here, although it doesn't seem like that is likely to happen. The real remedy here, I think, is if the American public are upset about this, it's not only in the courts or in Congress, it's also just by a public outcry to make it clear to President Trump and to his administration that this is really, a high priority issue that's concerning people. I do think there are political remedies, there are legal remedies, but the train is sort of leaving the station, and if they're going to happen, we need to see some action, imminently.
In this op-ed, the CDC directors called on Congress to exercise oversight authority over the Department of Health and Human Services. What can Congress do if they wanted to?
Congress certainly could hold hearings. They could start to subpoena, administration officials. They could certainly exercise, authority to restore funding to state and local health agencies that's been cut. I mean, I think there is quite a bit that they could do. I think investigating, holding hearings, demanding accountability from RFK, from the people reporting up to him, and filling some of the funding gaps are the obvious things that they could do. Candidly, it doesn't seem that Congress is, at this moment, demanding the kind of answers on everything from the vaccine policy to the leadership changes and the funding shifts that, people concerned with public health might hope that they would.
Well, Kennedy's going to appear on Thursday, I believe, so maybe we'll see some of that. But, Bill Cassidy, and he was the Louisiana Republican senator who delivered the key vote to confirm Kennedy. And I remember he said, something like, I'm trusting you on vaccines. He called on HHS to indefinitely postpone its vaccine advisory committee meeting on September 18th. That's not a long-term solution.
It's interesting. Senator Cassidy, who was as chair of the Senate Health Committee and as a doctor, was someone whose vote was clearly pivotal in the confirmation, seems to be trying to walk a cautious line here, asking for oversight, transparency, postponement on some of these critical vaccine advisory, meetings. He's definitely an important voice here. What's been disappointing to me has been that, RFK is basically just refusing to address, square on the issues. He seems to be just interested in deflecting blame and, kind of trying to stay on a higher level message about problems at the CDC and a need for strong leadership, but without really getting into the nuts and bolts of vaccine policy. And frankly, there's no way to see the actions being taken now as consistent with his testimony during the confirmation hearing.
He is suggesting Silicon Valley investor and entrepreneur Jim O'Neill is the new acting CDC director. Tell us about him.
Yeah, I think people are worried that Jim O'Neill is not coming from the world of public health and science. O'Neill, first of all, was a deputy to RFK already and seems to be aligned with his vision that he's just rebuilding the CDC. He's not expected to put any challenge forward, in the name of science or in the name of public health. It's likely that he's just going to be, a mouthpiece for RFK and for all the changes that are already being made. So I don't think anyone who's concerned about what's going on is at all reassured by O'Neill's selection.
Does the CDC director have to be confirmed by the Senate?
Yeah, the CDC director is a confirmed position. Yeah, I think a lot of it will flow from how much feedback the senators are getting from their constituents. It certainly is an opportunity to sort of take the pulse of where America is standing on these issues. My understanding is that he can serve 6 to 7 months without a formal confirmation hearing, so we may see this issue pushed off until, early 2026.
So Trump said he would allow RFK Jr. to go wild on health care, and he certainly has done that. Are there any restrictions on what RFK Jr. can do?
It's hard to see where Trump is having misgivings. I mean, there certainly are areas where they were aligned. We've seen, President Trump posting on Truth Social urging pharmaceuticals to release more data and sort of, claiming that there's some kind of hidden story about vaccine efficacy. I think it's funny because President Trump has taken pride at different points on Operation Warp Speed and the extent to which his administration brought the vaccines out in the middle of COVID when, by the way, we had in the course of 2 years, when you look at the data now, over 1 million Americans dead in the first 2 years of COVID. I think President Trump is largely distancing himself from RFK's specific actions and still trying to protect his vaccine legacy. I would think that there's probably some discomfort with the more aggressive aspects of RFK, but we have yet to see like a real action to sort of rein him in.
Well, what was surprising to me is that they had a Gallup poll in July, and Kennedy had higher favorability ratings than Trump and the vice president and others.
It's interesting. RFK he's obviously a very polarizing figure. I mean, his Make America Healthy Again campaign has a lot of resonance. He's clearly, someone who, for people who were excited about what RFK presented, he's delivering, right? Whereas President Trump is definitely having to walk a line, sort of affecting how people view him. But for people who buy into the public health agenda that's being carried out in this administration, to them, RFK is a hero.
Okay, so we talk about the negative things. Is he doing anything positive to make America healthy again?
There definitely are some good things. He's calling attention to big food and to, the need for a sort of new look at nutrition as a driver of health. The people who support him see him as a reformer fighting against entrenched institutions. And I think MAHA, Make America Healthy Again, speaks to people who are frustrated with public health bureaucracy. But the problem is that when you look at the op-ed piece that came out, for example, the other side has a strong scientific grounding to say that he's taking risks with American health by things like dismantling vaccine infrastructure. So there are things that are positive. He's calling attention to chronic disease. He's doing, good things to sort of try to create a populist focus on chronic illness in America and the way in which American healthcare could stand to be changed and shaken up. But I think we're seeing that he's also throwing out the baby with the bathwater on things like vaccine policy that I expect we'll see is really keeping Americans alive and out of the hospital in much larger numbers than without it.
How likely is it that during the winter months we'll see a resurgence of COVID without these vaccines?
I think that's a critical question, and I think we'll be watching. Obviously, nobody is hoping for bad news, but I think people are going to be watching very, very closely for the number of hospitalizations and the number of deaths. And I do think that clearly by narrowing vaccine eligibility to the 65 and older group and to people with a high-risk condition, there's a bet being made that those populations are the most at risk and have the biggest potential benefit. And on the other side is this, not backed up by science, that there's negative effects to vaccines for healthier, younger Americans. And so I think everyone should be watching the numbers month by month as they get released closely this season. And certainly we should all be praying for a mild flu season, not to have deadly variants of COVID, all the other flus that are out there, bird flu. We should obviously be hoping for the best, but we're definitely not coming into the season in a state of high preparedness if the opposite happens and if we have something deadly.
Well, as you say, let's hope not. Thanks so much, Harry. That's healthcare attorney Harry Nelson of Leech Tishman Nelson Hardiman. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.